Good afternoon, everyone, and welcome back to this week's episode of the Digital Law Podcast, brought to you by Digital Law and produced by Anson Evaluate. We're a law firm that works solely on these technology, cybersecurity, and legal issues. And as a bit of background, in each episode, we look at stories in the law related to digital technology from around the world with an emphasis on data protection and cybersecurity. I'm Amelia Davies, an apprentice solicitor at Digital Law UK, and I'm joined by my colleague Peter Wright. And we're just going to run through some of the news stories that have been coming up this week. I'll pass over to Peter to introduce himself, and then we will get started.
Thanks, Amelia. My name is Peter. I'm the solicitor and managing director at Digital Law, and looking forward to discussing a few stories that have been in the news this week with a particular relevance to law and technology, which is where we have our interest. So I will pass over to Amelia to start taking us through.
Thanks, Peter. So if you've been following the news this week, you'll have undoubtedly seen that Prince Harry has been back in London. I mean, all the tabloids are talking about it. So looking at this, he is back for a court case, and this is to do with privacy and unlawful information gathering by a company which also publishes the Mail on Sunday. So this isn't the first time we have spoken about phone tapping on the news. I mean, we spoke about it last year, I believe, with Sienna Miller. And Peter, you were talking to me about Millie Dowler and how the effects of that case are still kind of coming out.
Yes, so this is related to the phone hacking that has happened over a number of years. So the publisher that's mainly been affected by this is News Group Newspapers. That is the one that publishes The Sun, what's now The Sun on Sunday. And previously they did News of the World, and News of the World actually closed because of the issues around phone hacking and various other rather dodgy practices that meant they ended up closing it down. Such were the liabilities attached to it. Even then, over the course of the last decade, over £100 million have been paid out to claimants who have been pursuing claims against the news group, newspapers, for phone hacking of various types. So loads of high-ranking celebrities, and it got to the point they were paid off with settlement agreements, confidentially agreed after they'd started court proceedings. The idea being that you get so far, and then they ended up saying, "Okay, fine, you've got us. This is the amount that we'll pay." So that's what's been happening with News Group. As I say, massive liabilities that have ended up being set aside in order to deal with those, hundreds of millions. So that's affected the profitability of those newspapers in the UK. But other publishers have managed to sort of hopefully go past by going, this is nothing to do with us. We never did anything quite so underhand as nasty as that. It was all just those people at the News of the World and those in News Group. And this is an attempt to now widen the net for all of those who've been affected. So it's the same barrister who's acting as for the claimants on this, David Shawburn. He also acted for the claimants on a lot of the class actions when it came to the work against the news group. And they're trying to say, look, the Mail on Sunday was carrying out similar things from a period of 1993 to 2011, and indeed potentially onwards to 2018 as well. And that they have been engaged in doing things like accessing the voicemail remotely of different individuals, then potentially calling up and blagging things, so i.e. sometimes impersonating the individual to say, a hospital or some other organisation to try and get hold of records, and then potentially working with private investigators to go through the bins and access things that might have been thrown out, or even to actually have effected breaking and entering into the individual's properties to then acquire more information. So really quite aggressive covert surveillance techniques that have been applied to aggressively get people's confidential data. I think the thing to bear in mind is that very often people say, oh, it's just accessing voicemail. What difference does that make? And the answer is that it's actually quite significant, because say you've been speaking to your doctor over the phone and they're like coming back to confirm an appointment or something. So it could be, oh, hello there, it's the surgery. We want to confirm your appointment for a week on Thursday at 10 a.m. You might think, well, so what? What's sensitive about that? Well, even if they aren't confirming what a medical condition is, it's confirming that that individual has a medical condition of some sort that has required them to seek medical assistance. And then, is that an appointment with a GP? Is it an appointment with a hospital, which suggests something slightly more invasive, even if it's inpatient, outpatient, whatever. What if, for example, they go to a celebrity's voicemail, you access the voicemail, and it's an appointment at the Priory? Suggests there might be issues there with regards to their personal life, drugs, alcohol, who knows? So that would then potentially put journalists and investigators onto a totally different line of inquiry that they would not have known a thing about were it not having access to the voicemail. So that's where this stuff actually gets quite important. And that's therefore what is they're trying to establish here. This, I should point out, this isn't the actual trial. This is a sort of very early stage hearing to see if the judge is even going to allow it to proceed at this point before more costs are incurred by both parties. Bear in mind that this is High Court litigation with some of the wealthiest barristers and solicitors in the country, so the legal fees will be astronomical at this point.
So just to confirm that, so this is a 4-day preliminary hearing in London, and it's considering legal arguments, and a judge will decide whether the case will go any further. So the Associated Newspapers wants to end the claims without trial, but obviously the other side, so David Sherborne, he is wanting to kind of take this as far as they can, because it is such a gross invasion of privacy. And I was saying to you, Peter, I mean, even myself, I'm far from a celebrity, but I wouldn't want anyone else hearing my voicemails just because of the stupid stuff that's on it. And there we are. And celebrities have far more to lose than just me, a randomer that, you know.
Yeah. And unfortunately, the stuff now, I mean, how often now do we end up relying on phone calls? It's usually all via different means anyway. But the people that do tend to still use a phone call are people like doctors or banks or financial services, or your solicitor discussing a will, or, you know, the proceeds of an estate, or very often quite sensitive personal stuff, which is the reason why they want to talk to you about it over the phone. But also, I think it's important to bear in mind here the breadth of this. So it could be that they're talking about hacking into people's email accounts as well, or hacking into their phones, so you could then potentially access SMS text messages as well. So there's an awful lot here in terms of the sort of covert practices that they're potentially saying that journalists have been undertaken. One of the problems they'll have is the sheer breadth of time here, because if you're going back to 1993, that's 30 years ago.
Yeah.
So can you necessarily establish that such and such a practice happened? You know, that someone might be there saying, well, this definitely happened. You're like, well, do you have your phone records from then? The evidential burden to prove that actually happened, you're going to have something pretty dynamite there for a court to say, yeah, you've got a point, before they go, sorry, if this was an issue, you should have done it a long time ago. The other issue here they'll face is limitation.
Yeah.
Because this was allowed in terms of the court claims against newsgroup newspapers, and they acted on that at the time. This has now been rumbling on for the best part of 10 years afterwards, and the judge may turn around and say, well, hang on, you should have brought in Associated Newspapers back in 2009, 2010, 2011, if you were engaged in litigation against Newsgroup and felt that was going on. And if you had reason to think that Associated was also involved at that point, that's at the point you should have gone after Associated. You shouldn't have then sat on it for 7 or 8 years until you then felt you now wanted to come back for a second bite of the cherry. There's also the fact that some of these claimants may have already been compensated for, you know, they've been compensated for the sort of the suffering and everything they've had through the loss of data once. And as a general rule, you can't recover for the same thing twice. So that's going to be quite a key thing to discuss as well. So I'm going to be really interested to see the judgment that comes out from this, because it will create some interesting precedents either way.
Precisely. I don't doubt that we will be once again revisiting this in the next couple of weeks to see what that judgment is. Moving on to kind of another story that's looking at a gross invasion of privacy. So last year, we both covered this in our podcast, as well as doing a specific blog post on this. And this is Clearview AI. So essentially, Clearview AI are a facial recognition software that runs nearly 1 million searches for US police. And that's essentially what the founder has told the BBC. I mean, pretty damning there. So essentially, the company has been repeatedly fined millions of dollars in Europe and Australia for breaches of privacy, for essentially doing the exact same thing. And yet here they are again, repeating their actions, but just in the US.
Yes, and probably hoping that because of the patchwork of laws and enforcement when it comes to the US, that they can hopefully get away with it. After all, there's certain practices that quite big corporations manage to get away with in the US that they simply couldn't do anywhere else in the world. Scary thing here is the sheer scale of this. This chap, that the CEO has revealed that Clearview now has 30 billion images scraped from platforms like Facebook that it's then taken and added into its AI in order to then potentially identify people that come up on CCTV. And they've been fined already for this, as you said, in other jurisdictions like Europe and Australia. But in essence here, your image is then potentially being used in a virtual police lineup and being processed, even though you've never had anything to do with the commissioning of any crime or law enforcement, which is quite a significant leap. Because usually certainly in the UK, there's this principle now that if you do enter the system, if you ever are arrested for something, then they do take your DNA and they take your photo and all this information. So then if you ever come back into the system or your DNA comes up again in another crime, they can go, well, we know who this person is. In this instance, the personal data is being processed, even if you've never had any contact previously with the criminal justice system. That's kind of the scary thing. And then we are hoping that the AI is accurate and is giving a correct identification. What if it says, well, you definitely were a person that hit this person over the head with a crowbar, even if it wasn't?
Not only that, but I mean, there is no indication here whether all these 30 billion images have come from the US. So if we're talking about European citizens' data being scraped here and then used for US purposes, there's a whole kind of broader spectrum of, well, crikey, this really shouldn't be happening because it's not even citizens in their own jurisdiction.
Exactly. So we've got all these different platforms having their data pulled from them. Various ones where people will have supplied that data not thinking it was going to be used for this purpose, without doubt. And the fact that it would then be perpetual ongoing processing by this system, which is basically looking at all of those images each time it is being run in order to ascertain, well, what images can we identify anyone from the particular data that is in front of them at any particular given time. So it's the element of ongoing processing. It's not like they've just scraped it and then stopped using it for anything else. It will be, by the nature of the system, an ongoing level of processing and more data being added to it all the time as they try and make the AI tool more accurate. I think the point we need to point out here is that this is very much with regards to the fact that this is being used by certain police forces in the US. So Miami in particular, it seems, are looking at this. They've confirmed they're using the software for every type of crime. So everything from assault, murder, to shoplifting, jaywalking, they could be using this information.
I mean, as well, is it worth mentioning the fact that realistically, it also doesn't say whether or not this data is on children. At the moment, you have seen a lot in the news about how children's data is being used, and look at TikTok, for example, that is being banned left, right, and centre because of the security around data. If we've got Clearview AI here, who knows? I mean, I know for a start, my mum put me on Facebook, and if you've then got companies like Clearview using that data willy-nilly, and you've got children's pictures that obviously cannot give consent for their picture to be used, you've got an even bigger problem.
Exactly. And in this instance, we know that if they are scraping social media, the majority of people who use social media tend to be the younger demographics anyway, depending on the platform. So more than likely, you're absolutely right that they will be processing the data of minors. Bear in mind that the definition of a child varies from country to country, higher in some jurisdictions than others, but undoubtedly there will be a sizable cohort of information that is being processed. Even if it's the fact that the images are of someone who might now be classed as an adult, they may well have been classed as a child at the point when the data was taken, if it's from a few years ago, for example. So I think the thing we need to point out is that as far as we know here, this isn't being used on a wide scale in Europe, and that has faced regulatory enforcement in Europe. So we're talking about its use in the US. But funnily enough, when you see articles like this, and this is one from the BBC News website that we're using today, it wouldn't surprise me if in future days some agency somewhere turns around and says, we didn't know, we've been using it as well. some small agency like, say, the Metropolitan Police or some
Where there's
similar.
smoke, there's fire,
Yeah, exactly. Law enforcement isn't exactly covering itself in glory in the UK at the moment, so let's hope that isn't the next scandal to come out. I really hope. I think they've got enough to worry about without that as well.
So sticking with the theme of kind of data and cybersecurity, so obviously you will have heard, even if you've listened to the last couple of podcasts from us, that governments and institutions around the world have been banning TikTok from officials' phones and devices, and there's been a lot of controversy over the last few months. So while the Netherlands and Norway have also joined the list of countries banning the video sharing app, there is also instances, for example, in France, where essentially they have banned all recreational apps. So that's including Netflix, Instagram, Candy Crush, which I'll admit gave me a bit of a chuckle, and Twitter. So the ban is essentially, in France specifically, affects 2.5 million civil servants. Essentially it comes because there isn't sufficient levels of cybersecurity and data protection to be deployed against the administration's digital tools. So essentially they're just saying, oh, these apps are not good enough and they should not be on your phones.
Yes. This is an interesting sort of bit of follow-up here, I think, to remove charges of hypocrisy by a lot of governments that have turned around and said, well, we can't possibly have TikTok on our phone because it's terrible. Look at that, collecting all of this data and everything from GPS data to location data to information about what other people are sharing online and their searches and their texts and blah, 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 and we can't possibly have this. And the problem is that so many apps collect that sort of very rich data. So the ones here they've talked about are Netflix, Instagram, Candy Crush, Twitter. You could add virtually any app that Meta operates to that list. You can include Snap on that as well. There's a lot of, in particular, the sort of the GPS and location tracking on there is quite advanced.
I mean, we were discussing this earlier, Peter, because we were saying how in the office, how accurate GPS tracking has got. And for example, myself and my boyfriend, we're long distance, and I can use Snapchat Maps to pretty accurately describe the journey to get from my location to his. And that's pretty worrying when, realistically speaking, you don't want everyone to know that sort of information.
Exactly. And very often people end up sharing this information and don't even realise they're doing it. They might have just shared that information once to someone to say, oh, I'm meeting you here, or we're going to meet at such and such a place this evening, or we're going to this music festival and this is where we're going to be. But then you find that you're continuing to share that information, and depending on your privacy settings, you might not be just sharing it with the individual you thought you were sharing it with, but that could be a live beacon to everyone to see.
Precisely. It's like our colleague was saying today, she was taking a taxi somewhere and the taxi had shared his location. She didn't need the location, it wasn't for her purposes, but nonetheless she could still see it on her app. And it's just kind of thoughts like that, well, it could be used for nefarious purposes and you might not even know it.
Exactly. But the thing here is that so many of these apps do this sort of massive, broad collection of data, which is technically in breach of data protection rules, which say that you should only process the data that you need for the service that you're providing. So that's the first hurdle at which an awful lot of these services fail at. But I mean, we have to sort of look at the rock of the legislation in place that says you should only collect what you need for the purposes of providing your service. And then the fact that, say, an app like Candy Crush, the only reason that's free is because it goes onto your phone, collects all this data, and then passes it on to third parties. That's how they make their money. Nothing is ever given away in life for free, and I'm afraid that an awful lot of the apps that people might, enjoy on a daily basis are in fact, the thing you're paying with is all of your personal data. So in this instance, it's like, well, okay, we've banned that nasty TikTok, but if we're doing that, well, technically we should also ban all of these other apps from these public sector phones, and that's what France has done. So in the same way we've seen across the West recently, this sort of domino effect of different countries saying, right, well, we must ban TikTok from government devices, you'll probably now find them thinking, oh, we'd better ban all these other things as well.
I mean, interesting you mentioned that, because I was just thinking as you were speaking then, say, I'm not sure, Boris Johnson, for example, in the UK, he had an app like Candy Crush, and as you will have undoubtedly heard even from listening to our podcast or even news stories, that throughout the pandemic, there was confidential information shared via WhatsApp. So if you've got a combination of Candy Crush being used, which this is just an example, I'm not saying that they do collect this data, but if they are then kind of data scraping, you might find confidential information just floating around, like in WhatsApp, and that's then being collected, and people are none the wiser. And if that's sort of a precedent that's being set, then it could provide something very interesting.
Oh, the scary thing is that at a government select committee not so long ago, I think it was just before the pandemic, it was noted that loads of the politicians who were sat in there actually had their tablets up, and it looked like they were being very full and taking notes and, really being inquisitorial towards whoever was in there. In fact, several of them were just sat there playing Candy Crush.
Oh, delightful.
So it's been a common thing that they're using this thing during the court when they should be working. Let's face it, in fact, they're just frittering around doing that. But the point is that, the funny thing is as well, remove all these apps from your government phone, and guess what? The thing will actually work more easily. Its CPU won't be being, you'll have better coverage because you won't have all of these apps doing their usual data collection in the background. They won't be draining the battery in the same way, so the battery will last longer. It makes perfect sense. Ultimately, if you're giving someone a mobile device for work-related purposes, all this stuff shouldn't be on there anyway.
Precisely.
And really, businesses and organizations should have thought a lot about saying, well, if we're giving you this device and potentially a data signal so you can work from home, you shouldn't then be installing stuff like Candy Crush or Netflix on it anyway.
Well, you mentioned that. So we've been doing some work on looking at the Cyber Essentials, and that is one of the questions that the Cyber Essentials basic plan, might I add, is asking. Does your mobile device that's been given to you by your employer, does that allow you to essentially get whatever apps you want and just basically treat it as your own? And if that's the case, that is a big red flag.
Yeah.
Because you've got then potentially apps that could damage the integrity of the phone or anything that's being kept on it, and you open yourself up to a world of cybersecurity nightmares, essentially.
Yes. I think the other thing we need to just make the point here as well is that we are talking about devices given by government agencies to their staff. We aren't talking about personal mobile device use. Nonetheless, if there's a good reason why your employer is saying we don't want this on your device, I think it also gives individuals at the same time pause for thought to think, should I really have some of these apps on my personal mobile device, particularly if your personal device is the one that has your mobile banking on it, not to mention other payment apps. Let's face it, you can't actually park your car in the UK now without having about half a dozen payment apps or more, or ultra low emissions apps so you can drive into a city centre and out, or congestion charge payments. It's getting to the point now that you can't book a medical appointment with the NHS or be able to do much else without having an app and being able to do this through your phone. So if you're having to use your mobile device for all of those very important things, which involve quite rich personal data, which you are going to rely on, do you really want their operation to be overseen and watched by some of these quite invasive apps? And do you want the performance drag on your mobile phone? That means the thing runs out of charge halfway through the day because you've got all these things on there. So it's making people sort of perhaps stop and think. We use our phones now so much that actually I think we do need to think quite carefully, even with our own personal devices, about what we actually have on there.
Thanks, Peter. So that very nicely leads us on to our final story. So this is looking at Twitter. So essentially parts of the source code which underpins multi-billionaire Elon Musk's social media platform have been leaked online. It says that the code was spotted on GitHub, which is essentially a Microsoft-owned service where software developers share code. It has now been taken down, however, after Twitter requested its removal. So GitHub does not generally comment on decisions to remove content. However, in the interest of transparency here, they have shared every DMCA, which is the Digital Millennium Copyright Act, takedown request publicly, which is fairly unusual. However, it's important to flag here that the DMCA was signed in 1998. However, it's US law, therefore realistically does not apply in the UK. So I will pass over to Peter to continue with this bit.
Indeed, that's a really important point that you make there, Amelia, because it's fascinating how many people in the UK seem to think that the DMCA applies in the UK, and they've come to us saying, "Oh, we've received this," and you're like, "Well, are you a business in the UK? Yes. Is the individual making a request in the UK? Yes. Well, what's that got to do with this then? It will only the DMCA only operates in this instance because Twitter is a US organisation based in the US, and as is GitHub, so that's why it applies here as a piece of US legislation, a very long-standing piece of US legislation. Even then, it's worth bearing in mind when you think about it. This bit of legislation that was, drafted in 1998, years before social media and bulk data collection of the type we're talking about was taking place, let alone before complex code of the type that Twitter employs was envisaged. So you've got quite an old piece of legislation here being used for something that the people that drafted it would have had no possible way of envisioning that's just how it would operate in future.
Precisely, and it's quite interesting because from our standpoint here, this is an intellectual property issue because of the source code that essentially underpins it. And so one of our colleagues she has been essentially teaching myself and my colleague about how IP issues can come around and that it is not quite so straightforward as one might think. This is where this story is very interesting because it relates to a client that we have seen recently. So I will pass it to Peter to explain why this has come up for us.
Yeah, so the point here is that, on GitHub, yes, developers do frequently share code, very often sort of small bits of functional code, so they don't have to write something from scratch. They can literally cut and paste something into their program. But the point here is that quite often you can do that to a certain extent, and if you're then putting together one thing from one place and one from another and different bits from GitHub, though that's fine. The problem is when you could start getting to the point where you think that the thing you're putting together is then heavily based in all or part on one particular site. So if there was a large amount of code from Twitter up online and then someone took that and then used it to bring out a similar platform that allows for posts and sharing and all the sort of functionality that people know takes place on Twitter, then that would be fiddling directly with Twitter's IP, and they'll be able to come after you and say, well, actually, that is our intellectual property, and no, you can't go ahead and use it. So this is the thing that, in theory, stops the practice of sort of cloned websites, whereby someone takes the entirety of one site, cuts and pastes all of the code, puts it onto their own site, and that basically offers the same thing, perhaps for a cheaper amount or for free. And that can be a problem. So it's always actually quite important that when, for example, a entrepreneur might say to a developer, I want a site that does this, 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 and this, a bit like, say, an existing platform, you make it quite clear that you don't actually want that existing platform to be copied and cloned. Not only will it not work as well as the original, because it won't have the same infrastructure behind it, but B, you'd be basically front and center facing a claim for intellectual property infringement, certainly in a country that observes the rule of law. I mean, it's one thing if this is being operated from a country where there isn't a strong judicial system and where there might not be intellectual property enforcement of any meaningful type. That's where cloning is regrettably more of a common occurrence. But in this instance, where you're looking at a platform in the West and potentially it being that code being used by other developers, then you would potentially then face a claim for enforcement from Twitter saying, hang on, you can't copy our platform, or great big bits of it word for word, which is literally the case here, which could potentially happen given the leak of that huge volume of that code.
Not only that, I mean, I don't know about you, but I certainly wouldn't want to stand off against Twitter in relation to a legal issue. The amount of legal team that they would have behind them, I would quite happily say you'd not really stand much of a chance.
Well, you say that. He appears to have fired most of them over the course of the last 6 months.
That's very true. Potentially why, maybe this issue has come about. You never know.
Well, a lot of the work that was being done by their in-house legal team, certainly around the content that's on there, so policing content and applying their terms of service to that content, that's one of the things that has actually suffered by some of those teams being heavily reduced or indeed wiped out over the course of the last 6 months. Something like this, though, probably wouldn't end up going to the in-house legal team. That would be that serious. They'd just go to the nearest large American law firm and say, would you please sue whoever is doing this, and please blast them out of existence as quickly as possible, which they would then proceed to do.
Yeah, exactly. So no doubt we will be revisiting Twitter again. I mean, it seems to be a weekly occurrence at this point, but that was our last discussion for this episode. But if you'd like to hear more from us, including subscribing to our newsletter, as well as receiving information about subscriber-only podcasts and maybe additional events, then please subscribe to our premium via our Patreon channel using the link in the show notes. A big thank you again to Anson Evaluate for helping us to produce this podcast. And if you'd like to produce your own podcast or webinar, or would be interested to hear about AE services, please take a look at their website that you can find at www.ansonevaluate.com. Just a reminder as well, these episodes are available on our website, our YouTube channel, and podcast channels as well, such as Spotify and Apple Music, Amazon and Google Podcasts. And please feel free to leave us a review. And if you have any questions about what we've talked about today, please just drop us an email at admin@digitallawyuk.com. There we are.